case of the day is Shoemaker versus Sliger.
May it please the Court, Dinah Stein on behalf of Dr. Shoemaker and the Professional Association, and I would like to reserve 2 minutes, if it pleases the Court, for rebuttal. Thank you. And we are here today in this appeal on what I believe is a very important issue on the application and interpretation of Rule 9.340C, which frankly no court has directly addressed since, I believe, 1978 under a former version of this rule. Now, we contend and we ask the court to apply, starting with the basic principle which the Supreme Court has set forth in Amarace, which is that Florida generally does not recognize post-verdict prejudgment interest. The Amarace court made that clear, but it recognized a narrow exception to this rule. And that was exactly the rule that we're talking about today. It recognized that under 9.340C, the interest will date back to the verdict. But very significantly, the Amarace court examined its only other case where it applied post-verdict interest, and this was the Green versus Reddy case. And the Amarace case made a very critical and important distinction in the Green versus Reddy case. It said the difference in that case is that their judgment had been withheld. Here, judgment was entered. And that's what we contend is the absolute critical difference in this case. We had a judgment entered. It was entered months prior to the final post-trial proceedings ended in this case. It began to accrue post-judgment interest. Plaintiff, both sides actually appealed. This court reversed, but only the amount of the judgment. It said we reverse only to change the amount of the judgment. And we contend that under the prior laws of the courts of this state, that was not entry of a judgment, it was a modification of the judgment. And I go back to probably the most, one of the most significant cases we've cited, and that is the 4th District's decision in St. Cloud Utilities versus Moore. It's 1978 case, and there it was interpreting the virtually identical version of the rule we're talking about today, and it directly addressed when interest starts to accrue, verdict, judgment, or new judgment. And it held directly that when the amount of the judgment, actually what it said was that if the judgment is simply amended somehow, in that case the amount didn't change, that's a modification. But it did cite to an earlier common law decision called Smith versus Goodpasture, where the court had said even if the amount changes, that's a modification as well. And that's exactly our point here, is that here this court held that the trial court had to change the amount. That was all he was instructed to do. And this would be no different than if it was the defendant who had to seek relief in the appellate court. Had the court somehow reduced the amount and given the defendant the benefit of the appeal, certainly the plaintiff wouldn't be able to contend a windfall under the rule as plaintiff is interpreting it now.
Let me ask you this. If we agree with you, are we in conflict with the General Motors versus McGee case?
I think potentially, yes. I don't know that McGee directly addressed the same arguments, because here we're saying that it goes to the original judgment, whereas the defendant didn't make that argument here. That's where it gets a little tricky, because you could go to this court's decision in Dolgen versus Domkowski, where you just reverse. It's the flip side of the coin. In that case, this court reversed and remanded to change the amount of the judgment, but then recognized that the plaintiff conceded that there shouldn't have been post-judgment interest and remanded for interest starting from the judgment. So if there was a conflict based on that, it probably existed when McGee came out. So I think certainly that the trial judge felt compelled to follow McGee because it was the most recent case. But you could argue either way. I would say there's no conflict because the court didn't address the issue.
Is your understanding, McGee, the issue presented to the appellate court was, do we go to the verdict or do we go to the date of the amended judgment after the appeal? And they didn't and there was no argument about the original judgment?
Well, they wanted to go to DeMario date, right?
That's correct. They made a creative argument, the defense did. They said, yes, normally it would be the verdict, but it should be the date of DeMario, which is
The date of
the change of this.
change of law.
Correct, the time of the substantive law. So the Fourth District was not called upon in that case to address whether St. Cloud Utilities applied. And in fact, it's arguably, the fourth, if you were going to, and the three-judge panel could not have receded from St. Cloud, obviously. There's another case from the Fourth District, Gilmore versus Morrison, as well, where the appellate court ordered that the original judgment was improperly portioned and that the interest ran from the original judgment. So in order to find a conflict, if you were to disagree with McGee, I'm not sure it is a conflict because that panel couldn't have reversed itself. And the only time it directly addressed the issue was in St. Cloud Utilities.
How about the Hyundai case?
Sure, the Hyundai case that counsel raised, that factually was a classic example of what we're saying the rule applies to, because there was no judgment in effect at the time. Now, there's some language, I think, by the court, and I would submit in dicta, which does indicate that it reads Amarace to mean that it has to do with when the trial court was asked to enter judgment, and I would disagree with that. First of all, and as I argued below, we don't have that issue here because the plaintiff never raised any argument the first time around about timing of when the judgment was entered. They duly presented a judgment to the court, and he did enter it as soon as he was able to, and I think if there's a problem with timing, that's long gone and waived. But I would disagree with that dicta. I don't think that's what Amarace stands for at all. I think Amarace draws a bright line, and it says it's either post-judgment or if there's no entry of judgment in the first instance, you go back to the date of the verdict. So I do think there's some confusion in the Fourth District, which is all the more, I think, significant that this needs to be addressed directly, going back to the interpretations from the old version of the statute. The other thing I want to point out about that, the timing of things, and as we pointed out in the brief, the statute existed in a prior form. It was then when the modern rules were published in the 70s, the version of subsection C was removed. It was put back in 1984, and when it was put back in 1984, it was in the exact form it was prior to that, with St. Cloud Utilities on the books. So I submit that if the Supreme Court wanted to change the law, it would have said reversal if there's entry or modification of a judgment on appeal. They didn't do that. So
Is your position really that if there was no judgment entered, as in that one case where the judge said you get a remediator or a new trial and there was no judgment, that went up on appeal, or if there were a judgment for a defendant, zero verdict, zero judgment, and that was later overturned, those are the two situations, according to your argument, where the rule applies because you have to fix a date somewhere?
that's exactly our argument, and it's such a common sense approach because in that case the plaintiff was wrongly denied their judgment. The court should have done something at a point in time and didn't, and I think this rule fixes the injustice of having to wait for the appellate process. I'd submit it makes absolutely no sense to apply it here and give essentially what's a windfall when there's no reason for it by now just simply by operation of a modification of the judgment going back in time for the plaintiff. Again, if it had been the defense that had to seek relief as indulgent, you certainly wouldn't be fair to then give the plaintiff that gift essentially contrary to the common law of going back to the time of the verdict. So I would submit that the court apply really the common sense version that's been on the books since 1978 and even before. One more thing I want to point out, if you read the Green versus Reddy, both versions, the third district and the Supreme Court version, they say that their decisions were consistent with the old case, the 1930s case of Atlantic, I think that the railroad case, which again talks about reversals for changes in the amount in terms of a modification and not entry. So I would...
As a follow-up to Judge Edwards' question, he said if there's a zero verdict and the appellate court reverses and says, or zero judgment, and the appellate court reverses and says, re-enter the jury's verdict for $1 million, that situation would go to the verdict?
I think arguably it would. If it was entered for a defendant, so essentially you're on remand, I think you're vacating that judgment and just entering a new judgment. I think arguably if we had a situation like that, I could see that argument being made. I don't necessarily take a position on it, although I do believe one case was cited in the briefs at least that deals with that.
Okay. If you had, say, a $500,000 and $100 verdict, and $500,000 was for lost wages and $100 was for the ambulance coming to the scene, and the judge set aside the $500,000, said there's insufficient evidence, I'll enter a verdict for $100. And then it went up to the appellate court, and the appellate court said, no, there's enough evidence, reinstate the $500,000 and put it back to $500,100. Verdict or original judgment?
Sure, original judgment. The rule doesn't distinguish between amounts, and so in that case, we still had a judgment for the plaintiff, and so obviously the plaintiff would have the interest as of that date for the full amount, but it would be as of the date they got their judgment on the books. So unless your honors have additional questions, I'll reserve the rest for rebuttal. Thank you for your time.
May it please the court, I'm David Sales. I represent Sonia Sliger, who's the personal representative of the estate of her late husband. I'd like to begin where Your Honor, Judge Evander just left us, because I think it points out what the problem is in this case and why the court should feel compelled to, as it should be anyway, most respectfully, to follow the plain language of the rule. Counsel's point of departure was that there really wasn't a reversal of this court, by this court, of the trial court's decision. Actually, what happened is the McCall case, which was decided by the Florida Supreme Court on certification from the 11th Circuit, decided an incredibly important issue in Florida law, and that's the constitutionality of caps on damages in malpractice cases that was passed by the legislature. We raised that on cross appeal because the judge in this case felt that the statute was constitutional and applied the cap. And the upshot of the cross appeal, which happened, which was successful only after the mandate was recalled, was that this court followed McCall. McCall had been pending, as I recall, in the Florida Supreme Court for 3 years, and it's a case of considerable importance in the state. To suggest that what happened as a result was a mere modification of the judgment, I think is incorrect based on those circumstances. The court was addressing an issue of constitutional law and whether a restraint on the ability of the plaintiff in this case to recover money damages was a valid restraint, and this court was obliged to conclude, consistent with McCall, that it was not. That takes us back to what Your Honor was talking about just a few moments ago.
Let me ask you this, because I want to see if we agree with you whether we have how it's going to work in other situations.
Right.
Okay, if you have a $2 million verdict, and then there's some post-trial motions, whether it's because of a cap or comparative negligence or negligence of a third party or sufficiency of the evidence, and the judge enters a verdict for $1 million. Okay. If there's no appeal, when does the interest run from?
The interest where there's no appeal would run consistent with 55.03 Florida statutes from the date of the judgment.
Okay. Now, if there is an appeal and there's an affirmance, so trial judge got it right,
Right.
when does it run from?
If there's an affirmance, it would run from the date of the judgment again.
And then
And
we
that's
have,
5503 and Amarace. Clear cut, there's no question about
now
it.
in this case, it'd be similar to a situation where the appellate court says reinstate the $2 million.
Right.
And you're arguing it goes from the verdict.
That's right.
Okay. And how about the situation where?
And that's actually, if I may just interrupt you briefly, Your Honor, that's actually effectively what happened in this case, because
Right.
there was a judgment entered.
Right.
Interest would have only run had there not been a rejection of the trial court's conclusion on constitutionality. Interest would have only run from the date of the judgment. But because of the application of the rule, which is clear, and I'd like to address that in a moment, the court applied the interest running from the date of the verdict consistent
Let
with
me
the
give you
rule.
my fourth scenario, and that is $2 million verdict, $1 million judgment, comes up on appeal, there's appeal, cross appeal, whatever, and the appellate court says, there wasn't enough evidence even for the $1 million, it should be $500,000.
We have a case like that.
Okay, so when is the interest?
That's
run?
Reddy versus Green, and 9.4.
Reddy versus Green, there was no judgment entered at all. I'm saying.
Well,
I'm saying, follow me on this hypothetical, $2 million verdict.
Right.
$1 million judgment, appellate court says the judgment should have only been $500,000.
Right. Interest runs if the rule is to be applied from the date of the verdict.
Okay, does that make sense in that scenario for the?
The last of them,
Let me finish
yes,
my
Your
question.
Honor.
For the plaintiff to get the benefit of a longer period of time for interest when their verdict was reduced from $1 million to $500,000.
The tension is,
Their judgment was reduced from $1 million to
the tension is the greatest in the last of those examples. But if I could go back to where I was headed with what happened in this case, and we don't have a record on this, but we're really arguing policy here. So let's just suppose, if I can give Your Honor a counterexample, let's suppose that the reason for a delay in the entry of judgment in this case, which was in the order of months, wasn't a fault issue, because Amarace does talk about that, and it does seem to be a consideration that was important to the 4th District. It wasn't a fault issue, but let's suppose that the court was faced with a claim. And if you go back and actually look at the original trial record, in this case, in the post-trial hearings that Ms. Stein and I attended, Judge Kess said, I think we have a problem with the constitutionality of this statute. He ultimately ruled that it was constitutional and rejected our point. My point simply being, and we don't have a record on this, but what if, to give Your Honor another example, the reason for the delay was the court being troubled, the trial court being troubled over the constitutionality of the statute. As it turned out, the plaintiff was burdened with what turned out to be an unconstitutional law. And my point about this is you could turn these fairness and unfairness examples into 100 different scenarios.
But if we agreed with you, would our opinion have the effect of that last scenario, meaning that if the appellate court reversed the judgment, that the interest would go to the verdict? Or is there a way to say, that wouldn't be fair in that scenario, so only if the appellate court goes higher than the judgment?
I think if I was a student in Your Honor's appellate review class and it was the first day of class, I would respond to Your Honor by saying, if I wanted to get a good grade, that you should focus on the case that's in front of you. And I do understand. Yes, Your Honor.
In opinions, we have to be worried about how it's going to be interpreted in other situations.
Right.
We write opinions for two groups of people, one for the parties and two for everyone else that may follow along.
Yes, Your Honor. And my next point, I hope will be helpful to the court on that, because yes, while all of that is true, you're guided most importantly by the Florida Supreme Court and what it has done in the past. And so I'd like to talk about the two cases that actually address this rule. While it is important, quote unquote, it is of note that no appellate court in Florida has spoken about this rule since 2004, I think is the correct date. But let's take a look at the two cases that the Florida Supreme Court has actually addressed. One is the Amarace case. That is a very important decision because it influences and raises the importance, if you're the plaintiff certainly, of trying to get a judgment entered as soon as possible on a verdict. And that sometimes causes problems of its own, and we have to educate trial judges about the consequences of their failure to do so. But that's a straight-up situation where the court says, verdict, judgment. The trial court refused, in that case, to give what is sometimes referred to as post-verdict but prejudgment interest, that window between the verdict and the judgment. And the second DCA reversed, saying, hey, you know, once it's liquidated, that erases some of the concerns that we have. And the Florida Supreme Court said, no, 5503, we have our rule. And then it goes on to, and so post-verdict prejudgment interest could not be authorized. And that is, as Ms. Stein has amply reported in cases that don't actually touch on all of these issues, that has been the consistent rule overwhelmingly with respect to that particular scenario. But the court does talk about the Reddy case. And what is the principal and most important distinguishing feature of the Reddy case? What separates the 5503 universe from the Rule 9.340C universe? And if you look at them and fairly read the Amarace case and then go back to Reddy versus Green and the third district's decision, I would submit to your honors that the distinguishing principle is a reversal. And that's where your honor started in your honors questions to me. Because what happened in that case was that there was a appellate decision ultimately that said a trial court bit too much out of a verdict with its remittitor and ordered that the quantity of the remittitor be in fact reduced. And the court is very clear, if you take a look at the decision, that there was in fact a reversal of that aspect of the opinion. And if you go back...
No judgment entered. That's why, and that's the problem I'm having with this. If you look at the rule as saying, when the plaintiff doesn't get a judgment for money damages in its favor, initially, goes up on appeal,
right,
and the appeal results in, now you get a judgment for money damages, you have to start somewhere. There has been no judgment for you before, so you have to go somewhere, so the rule says, hey, I know, let's go back to the date of the verdict. But when the judgment is modified, which is really, I mean, I know you disagree, you think it's reversal and therefore a whole new judgment, but where the judgment is modified, you already have a starting date.
But the court in Reddy indicated, and that's why we pointed this out, that the presence or absence of the verdict didn't make any difference. And, excuse me, the presence or absence in the application of 9.340 in that case didn't make any difference. There was no, it has language which we cite in our brief, I don't have it memorized, but suggested that the presence or absence of the judgment was not the distinguishing feature. And you know, I mean, we started in our brief with the concept that the court is obliged most respectfully to deal with the rule for whatever reason that the Supreme Court has promulgated. I believe, because I expected to be asked, why would they do this? And I think that the bright line is a bright line that should be drawn for the reasons that I'm suggesting. We shouldn't be putting the trial courts in the position of doing what this court is being asked to do, we submit by the defense, and that is to say, if you look at all of their cases, it's a function of whether the money went up, the money went down, the judgment was withheld, whether there was an order on new trial. And if you take this rule, which our cases on statutory and rule construction teach us, we cannot add or subtract words from. It says, if a judgment of reversal is entered, which requires the entry of a money judgment on a verdict, the mandate shall be deemed to require such money judgment to be entered as of the date of the verdict. It doesn't allow for the different scenarios that have arisen and been discussed in cases cited by the defense, which overwhelmingly don't actually even cite this rule. And I have asked myself, you know, why is that so? And I would submit to the court that there is just the possibility that a lot of lawyers are not very familiar with this particular rule. Most of this happens in the trial courts. Most of the trial lawyers are not looking at the appellate rules of procedure, and most of this energy that is being discussed in the cases that have been cited by the defense predate the rule. They do have the case that they cited, the 4th DCA case Moore, which refers to a prior version of the rule. And interestingly, if you look at the cases, there's a discussion, and the name of the authority that contains this language is escaping me for the moment. but there's a discussion somewhere that says, you know, we had this rule in 3.15, and then it disappeared, but it was determined that it was necessary again. You know, you are dealing respectfully with Ms. Stein and me. I can assure you, although we haven't discussed this very issue, that both of us have looked long and hard to try and figure out why the court has done these things, and there isn't any academic comment on it. There isn't any scholarly article on it. We have the rule that the Supreme Court gave us, and that rule says what it says.
So it's basically your position that if the opinion from the appellate court says reversed and increase, decrease, anything like that, under the rule requires that go back to reverse remand, assuming that it's a change in number and change in amount, not whether there's liability or no liability, but just an amount.
Again, going back to my hopefully graduate level appellate review class, I think my first answer, if I may, Your Honor, is to look at what this court said in this case and then answer Your Honor's question, because what the court said in this case is we reverse that part of the judgment under review that reduces the award of wrongful death, non-economic damages.
I'm saying
Right.
your position is that the appellate court says reversed, and the result is the judgment either is to go up or down. That your reading of the rule and that the proper reading of the rule is you then go to the verdict.
It's yes, but there's more than that. Let's suppose the trial judge entered an order of new trial that was later reversed, basically going from a verdict, whatever amount, down to zero, and the parties were supposed to start over. In that instance as well, that would be the outcome. And similar to one of the questions that Your Honor asked me earlier, you know, we have this odd occurrence that happens after a trial sometimes, because the time for an appeal can run either from the denial of a motion for a new trial or from the entry of a judgment. And sometimes there's and I'm sure Your Honors deal with that when there are premature notices of appeal and so forth. So there is some...
Scary time, right?
It can be a scary time, and that's when the rule book is always out and open. But you can have situations where there's uncertainty as to what's to happen. And as in the example that I previously gave, I think the reason, although we can all reach absurd results in our minds with respect to these things, is that the court should not be trying, especially on review, in trying to estimate why it was that these things happened. Now, I say that with the knowledge that the Supreme Court in Amarace does seem to say that Rule 9.340 applied because owing to or not owing to something having to do with the fault of a party in respect of the speed with which a judgment was entered. And they said, well, you know, you could have come in right after and gotten a judgment entered. We who toil in both courts, we know that that's not true sometimes for a variety of reasons.
All sorts of issues.
Right. And some judges just feel...
You gotta get the hearing time, and then you gotta wait for the judge to
Right.
rule.
And sometimes trial judges feel, understandably, that they can't enter a judgment, even though they can, before they rule on a motion for a new trial. And so I think that that's an additional rationale that would support the reading of the rule that we're suggesting to the court.
When you point to the opinion of this court reversing this case to enter the judgment, the St. Cloud Utilities versus Moore, they drop a footnote basically where they talk about exactly the same thing, and that court goes, yeah, I know we said reversal, but we didn't really mean reversal, we meant modification.
Right. But the rule doesn't say that. And if you take a look, and I think it is worth noting, because I understand Ms. Stein's distinction of what happened in Reddy versus Green, but it is important to note that the Supreme Court approved the decision of the third DCA. And if you take a look at the decision of the third DCA, they talk about the very things that we're discussing. On appeal, this court held that the remitter was too large and the resulting damage award was too low. This court set the aggregate award against Green at $5 million and remanded with directions to give Reddy a reasonable time within which to accept or reject the remitter, and Reddy timely accepted. The defense in that case said, well, you know, the rule shouldn't apply because it wasn't clear that the verdict was going to result even after being reduced in the entry of a judgment, because Reddy could have rejected the remitter and caused there to be a new trial with no judgment being entered at all. So that gives Your Honors, I think, a sense that it isn't one of these things where it's only the circumstance where a verdict where a judgment is adjusted up or down based on what a jury did, I think the fact of this scenario applying where there's a remittitor actually supports the plaintiff. But the very next statement that the third DCA made, which was approved by the Supreme Court, is, as a threshold matter, the judgment against Green fits within the definitional scope of the rule, and it describes it a little differently. This court's ruling was indisputably a judgment of reversal, which reversed the trial court's order of remittitor or new trial. The unresolved question is whether entry of a judgment on the reduced amount constitutes entry of a money judgment on a verdict. So they weren't actually struggling in that case with whether or not the rule applied for the reasons that your honors are discussing with me. They were just struggling with the concept of whether or not this was actually fitting within the rule for the reasons that I explained and owing to the remittitor. So I think that if you take that together with what actually happened in the Supreme Court, it supports the plaintiff. Now, I just would like to note that, because there's some suggestion of conflict, and, it's funny you mentioned that, Judge Evander, because one of the things I said to Ms. Stein before the argument today is, do we have express and direct? And, we're both scratching our heads over it, or I should just speak for myself, I'm scratching my head over that somewhat as well. And certainly the 4th District has been inconsistent in this area.
We could argue we have a conflict one way with
Either way.
with the General Motors and the other way with the Moore case.
Well, but you also have the Brown versus Stuckey case where, the interest ran from the date of the verdict. You've got the Hyundai versus Ferriorni case where they seem to apply the rule. You've got the McGee case where they seem to apply the rule. And those are, does that erase what was done, at a time when Rule 3.15 applied or not? Obviously, I'm struggling with that a little bit myself. Can you have express and direct conflict when it's based upon a rule that doesn't exist anymore, even though it contains an identical or similar provision? And that's one of the reasons that I've been scratching my head over a little bit over that. And the last thing I'd like to say is that the counsel also cited in the brief the Dolgen versus Dombrowski case, which she was actually argued to this court back in 2006. And I don't know if the court hasn't focused on that today, but the court did find or did conclude that interest would run from the date of the judgment rather than the verdict in reverse. But here's what the court said about that. Because the appellees properly concede error in the trial court's award of prejudgment interest from the date of the verdict to the date of the final judgment, we reverse on this issue. I don't know if the properly meant that the court thought that there was a confession of error that should have been made. I don't know if the properly meant that it was an act of professionalism. I don't know if the court was concluding that it agreed with the position of the other party. But I would submit to the court that the court did not actually consider the issues, as far as I can tell, that have been raised by the parties here. Thank you very much.
May it please the court, and I do think both sides have tried very hard to cobble together a lot of cases and try to make meaning from them and say what they mean. We could argue over what the courts meant in Green versus Reddy. I don't know that we have to argue, though, because I think the Supreme Court told us in Amarace, and I'll read right from the Supreme Court's language where it said the controversy in Green arose because the trial court originally withheld judgment. Since the appellate process can last months or even years, Rule 9.340C provides that in cases such as Green, interest should be computed from the date of the verdict. In contrast to Green, judgment was entered in the present case. So we submit that the Supreme Court, I think, has subsequently made clear what it meant in Green, where the arguments were slightly different. As far as, I'll go back just very briefly to timing. Certainly there are always issues of when a judgment's entered, and I often see in practice the plaintiff will ask for interest if they submitted a judgment timely, nunc pro tunc. There are things the court can do to fix things like that, and obviously if there's a problem with the timing of an entry of judgment, again, I submit that's to be raised on direct appeal and not in a subsequent appeal now. And again, I think the Amarace court made a bright line rule, and it talked about the fact that the court would have entered a judgment, and so they're not going to start considering these things. You either have a judgment or you don't. As far as, again, the wording of this court's reversal, again, I think you look to the substance of the ruling and what it does, and here, again, we had a judgment in place to begin with, and so this was simply changing the amount of the judgment, and I hark back to the older cases which make it clear that this was a modification of the judgment. So unless your honors have additional questions, yes, yes, Your Honor.
Do you believe that you have to interpret the rule to apply the same way, regardless of whether the appellate court directs that the amount of the judgment be increased or directs that the amount of the judgment should be decreased?
If you were going to take a literal reading, I think it would have to be both ways, whether it's an increase or decrease. I don't know.
Either they both go to verdict or they both go to judgment.
I don't want to make bad case law, but that's what I'm saying is the absurdity of the argument, that if the defendant successfully gets a reduction in the judgment, I don't believe that common sense and the wording of the rule should go back to the date of the verdict, yet if we're going to take plaintiff's argument, that could certainly, I'm not sure how you'd fashion a decision which would only apply if the plaintiff won under the wording of the rule.
Okay, well, thank you both. Again, an interesting case, well argued. Appreciate the argument.
Thank you, Your Honors.